Today we have to talk about Karen Read. She said through her lawyers a month ago, more than a month ago, that she was going to sue everyone.
From Ms. Read's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sgt Yurity Bukhenik in his personal capacity, Michael Proctor. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, and then a claim against the Town of Canton through its police department for negligent failure to secure the garage in the Sally Port.
And so she's suing everyone. It's Wednesday, November 19th. Today, we're going to talk about that lawsuit. It is 46 pages long. I've been waiting to go through it with y'all. Let's see if we've got the receipts, the screenshots, the timeline, fucking everything. Who knows? Let's see. But what we do have is a list of those that she's suing. We have some information why the Town of Canton and MSP is not yet sued, and much more, because we've got the Alberts, the McCabes, Higgins. Why do they all have the same lawyer? And we have trickling out of statements from all of the lawyers. So we're going to talk about all of it. This is coming from Boston.com. The Alberts, McCabes, Higgins eyeing defamation claims against Read and Turtle Boy. That's the headline. The witnesses from Read's high-profile murder case are denouncing her cover-up claims as a vile work of fiction. That is a direct quote. Still hounded by conspiracy theories, months after Karen Read's acquittal, several witnesses from the high-profile murder case are denouncing Read's cover-up claims as a vile work of fiction. The quote-unquote outlandish frame job allegations were part of Read's, quote, scheme to defame and wrongly malign prosecution witnesses and evade responsibility for the death of her boyfriend, John O'Keefe. Lawyers for Brian and Nicole Albert, Jennifer and Matt McCabe, and Brian Higgins argue in a new brief recently served on Read's legal team. I don't have the brief. I want the brief so badly. But this is in briefing about whether or not these cases should be consolidated because those motions are underway. That's the only thing that makes sense. Read is seeking to combine her conspiracy and civil rights claims with the wrongful death suit for efficiency's sake, but a judge has yet to rule on the request. The Alberts, McCabes, and Higgins are asking that Read's motion be denied and her claims filed in a separate case, which she has now done. It does not mean that they cannot be consolidated together later, or they can be related. Related means the discovery can go together even if they don't go to trial together. Consolidated means everything goes to trial, and the jury, can you imagine that the jury has to decide the wrongful death lawsuit and then decide the suit we're going to read today and then maybe decide a defamation suit? It goes on to say that the, quote, Commonwealth witnesses vigorously dispute defendant Read's allegations and will defend against these false claims, their lawyer explained. They said that their defense will include motions to dismiss, a potential request to move the claims to federal court, and counterclaims against both Read and Turtle Boy blogger Aidan Carney for defamation and other torts that they have committed individually and in concert. So then we could actually end up seeing them bringing in Turtle Boy into this whole thing as well. It goes on to say lawyers for the McCabes, Alberts, and Higgins said they had, quote, planned to seek justice in a separate action over allegations that Read and Carney defamed and substantially injured them through a myriad of false statements. Combining those defamation claims with Read's conspiracy claims and the O'Keefe's wrongful death suit is procedurally improper at this stage and will make for a much more sprawling case, the lawyers argue. It will be sprawling. Reached for comment on the potential defamation claims, Read defense attorney Damon Seligson said via email, quote, truth is an absolute defense to a claim of defamation, and we will defend Karen Read vigorously against such baseless claims. That's where we're at on the will there be defamation claims. The wrongful death lawsuit is due back in court on Friday. So if they are going to be arguing that on Friday, I'll have to take a look at what time and if it'll be streamed. Honored, you know I love a sponsor that makes things easy, and Hungryroot does exactly that because it is fresh food delivered to your door, and you can choose whether you just need groceries, snackies, meals, and you can change it up week after week or pause it if you're traveling. It's perfect for this busy time of year. So whether you want to be able to put together dinner or lunch or breakfast, or you just need grab and go, Hungryroot has you covered. And unlike other things you may have tried, Hungryroot has over 50,000 recipes to choose from every week. Plus, you can sort by how long they take to put together. I absolutely love the different types of garlicky non-wraps, and I always add my favorite vanilla protein pancakes to every order. Plus, the sour crunchy gummy rings are a 10 out of 10. So if you need help having meals picked and planned, groceries delivered, and you need the flexibility to choose, Hungryroot has you covered, and I've got you covered with a discount. So take advantage of this exclusive offer, and for a limited time, get 40% off your first box plus a free item in every box for life. Go to hungryroot.com/Lawnerd and use code Lawnerd. That's hungryroot.com/Lawnerd and use code Lawnerd to get 40% off your first box and a free item of your choice in every box. Look, we all need to eat. We might as well just make it easy. And now let's get back to today's show. So this is from Ted Daniel, who said, I reached out to lawyers for the McCabes, Alberts, O'Keefes, and Brian Higgins about Karen Read's new lawsuit and their proposed claim against her. I'll let you know if I hear back. He did. We'll go through that after the claim. This just released statement is from Alan Jackson and Karen Read's civil team. Quote, today's filing speaks for itself. Res ipsa loquitur. The thing speaks for itself. It is a meticulously documented civil action grounded in evidence, law, and the Constitution. For more than 3 years, Karen Read was dragged through a baseless criminal prosecution engineered by individuals who abused their authority, manipulated the investigative process, and trampled her rights. Our complaint lays out in stark detail the malicious prosecution, the conspiracy, the civil rights violations, and the intentional misconduct that these defendants visited upon an innocent woman. If these defendants want to answer for that under oath, we welcome it. What we will not do is legitimize a threat to file some imaginary quote unquote defamation case. That threat is nothing more than a desperate attempt by these defendants to distract the public from the very real legal jeopardy they now face. When people start waving around defamation claims to mask their own legal troubles, it tells you everything you need to know. They don't want sunlight. They want silence. The quote goes on to say Karen Read spent years fighting for her freedom against a corrupted investigation. Now she is fighting for accountability. And unlike the criminal case, this time the defendants don't get to hide behind badges, back-channel favors, or manufactured narratives. They will have to answer in a court of law for every lie, every omission, every manipulated report, and every constitutional violation they committed. You can hear Alan Jackson like banging the table. Karen Read is not backing down. Our team is not backing down. Accountability is coming, and these defendants can threaten all the phantom lawsuits they want, but the truth doesn't flinch. This was filed November 17th, 2025. You'll notice there are two immediate footnotes on this. Karen Read versus. On the other side of the V, Michael Proctor, Bukhenik, Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe, and Brian Higgins. Defendants. Footnote 1. The Massachusetts State Police and Town of Canton will be added as defendants after presentment is made pursuant to the code. Just a note, suing government entities requires a lot more hoops to be jumped through. So they're going to have to go deal with the hoops. So they're saying it's coming, but we're going to have to jump through the hoops. Complaint. Footnote 2. Plaintiffs intend to move to consolidate this action with the related action, Estate of John O'Keefe versus Read et al., for discovery and trial efficiencies. They are still going to try to connect this case to the other case. Introduction. For 3.5 years, plaintiff Karen Read was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, public condemnation, all resulting from the gross misconduct of Massachusetts State Police, MSP, and those working in tandem with MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death. They go on to say Ms. Reed's life was not merely turned upside down by MSP and the House defendants' misconduct, it was forever changed by the defendants' transgressions and wrongdoing. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. I don't doubt that. I don't think it's hyperbolic either. At the same time, neither Mr. O'Keefe nor his family have received justice. His killer or killers still walk free. But asserting her claims against MSP, Proctor, his supervisors, Canton, the House defendants, Ms. Reed seeks, at minimum, to confront and redress these wrongs in others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. It's a strong sentence. Then they go on to talk about the impact, because there is an IIED claim here. So they're now talking about the impact to Karen Reed to support her claims. Beginning in January 2022, the defendant's actions have had profound effect on Ms. Reed. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car and her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed. She incurred multiple millions of dollars in debt for legal fees and additional millions in experts' fees and costs. In addition, after being arrested twice, jailed twice, and tried twice, she has suffered years of intense stress and emotional harm, worried that she would be imprisoned for the rest of her natural life for a crime she did not commit. This goes to those claims. Remember, this is a civil case. The way that civil makes things right is most often money. Ms. Reed suffers from both Crohn's disease and MS, multiple sclerosis. As documented under seal with the criminal court, Reed has undergone tens of surgeries to manage her illness prior to January 29, 2022, and endured blood infusions just months before O'Keefe's death. In the aftermath of the charges to arrest and during both trials, Reed has suffered well-documented exacerbation of her symptoms amid the stress, anxiety, and emotion and physical impacts of being wrongly accused of murder. Stress and MS are not a good combo. While fighting for her freedom against a corrupt prosecution, Reed underwent dozens and dozens of documented medical procedures and treatments to attempt to address her health issues. And this all amid losing her job and her health insurance. They say the defendants concocted a plan, executed a plan, and framed an innocent woman and are now responsible for these extraordinary damages that Ms. Reed has suffered at their hands. Now we're getting into what they are suing for. Footnote 4, after making presentment pursuant to rules, Reed will add counts against A, MSP for negligent training, supervision, and retention of MSP troopers, including Proctor, Bukhenik, and Tully, and B, the Town of Canton for negligent oversight. So we know that those are the two different causes of action that are going to be brought against the government entities. So a count against MSP for negligent training and supervision, and a count against Canton for negligent oversight of the investigation. Count 1, malicious prosecution under the Fourth Amendment against Proctor, Bukhenik, and Tully. Remember, to bring malicious prosecution, you have to first win. Karen Reed won. A lot of you at the end of this were like, where is the malicious prosecution? There it is. Count 1. Count 2, supervisor liability against Bukhenik and Tully. Hey, boys, what you doing? Shouldn't you tell Proctor that this isn't okay? Instead of like thumbs upping the text. And both of them got in trouble for this already with the IA investigations. Count 3, conspiracy to deprive Reed of her Fourth Amendment rights. Proctor, Bukhenik, Tully, Alberts, McCabe's, Higgins. All of them conspiring together for her to take the fall and knowing it was false and continuing to go forward with it. So everybody together in a conspiracy to, as Reed's defense attorneys, well, now civil plaintiff's attorneys characterize, to pin it on the girl. And then they talk about her loss of employment, her reputational damages, distress, etc. Count 4, Massachusetts Civil Rights Act against Proctor, Bukhenik, Tully, Alberts, McCabe's, Higgins. So civil rights violations at all. Count 5, common law, malicious prosecution against Proctor, Bukhenik, Tully, Alberts, McCabe's, Higgins. I want to look at that because some of them are civilians. I don't know if common law malicious prosecution extends. I imagine they researched that, so I'm going to go with what they said. I haven't seen it done. It doesn't mean it can't be. So common law malicious prosecution, I imagine the statutory one requires you be law enforcement or a prosecutor, but I'm really interested in taking a look at this. IIED, intentional infliction of emotional distress against everybody. Proctor, Bukhenik, Tully, Alberts, McCabe's, Higgins. They did this. It was intentional. It caused distress. Obviously, it caused severe emotional and physical distress. And Reed suffered emotional and physical injury related to that. Count 7, civil conspiracy. Proctor, Bukhenik, Tully, Alberts, McCabe's, Higgins conspired together, had an agreement, and saying as part of their concerted effort and among their many other misrepresentations, the Alberts, McCabe's, and Higgins agreed with each other to tell investigators that John O'Keefe never entered the house, that they did not see him in the house that night, and that Reed made inculpatory statements. Demand for a jury trial, prayer for relief. Find them all liable. So the prayer for relief is enter judgment in her favor against each relevant defendant on each count, award damages in an amount to be calculated at trial along with pre- and post-trial judgment, interest, and expenses. Reasonable attorney's fees incurred in connection with this litigation. If you sit on this jury, would you be curious about if you could give her attorney's fees for all the trials? And that might fall under such other relief, such other equitable relief. Attorney's fees, not just for this, but for everything. I am not surprised this is done in connection with Seligson, the civil attorney, and Jackson, who with his firm is still on this, because there's going to be a lot of lawyers involved, and they're involved in the civil wrongful death. This was given to Ted Daniel, November 18th, 2025. New statement from the attorneys for Brian Higgins, Alberts, McCabe's. Quote, the allegations made by Karen Reed are entirely false, defamatory, and without merit. They can't be defamatory if they're in court filings. Our clients categorically deny each and every claim. This lawsuit is nothing more than a continuation of a baseless conspiracy narrative that has caused significant harm to the reputations and lives of innocent people. Our clients have acted responsibly, fulfilling their civic duty as witnesses, and have participated appropriately in the legal process from the outset. Counsel. Ms. Reed's claims distort the facts, misrepresent the evidence, and target private citizens in an attempt to deflect blame. As reported yesterday, we will hold Ms. Reed accountable for the harm she has inflicted and the conspiracy she and Aiden Kearney, also known as Turtle Boy, have manufactured. Oh, they're doubling down on the defamation lawsuit. Karen Reed has sued everybody. She has sued Proctor, Tully, Bukhenik, the Alberts, the McCabe's, and Higgins. Strangely, the Alberts, the McCabe's, and Higgins all have the same lawyer. I don't think that'll last. I think it's a terrible idea. She also has indicated that after the red tape that you have to go through when suing a government entity is done, that she will also be bringing suit against Massachusetts State Police and Canton. So we will see 2 more defendants added into this and 2 more causes of action or claims added to them. There are 7 claims here that we just went over. This is what they are arguing over in the wrongful death case. Will this case be added to the wrongful death case? As I said earlier, that can happen in 2 ways. Either they get consolidated, which means everything goes to trial together, one trial, or they get related, which can mean that you can overlap the evidence, you can overlap the discovery. Could we see 2 juries? Possible. It's possible that they could bring in dual juries and have a jury for this case and a jury for the wrongful death case and have 2 juries. I don't know what courthouse they would facilitate that in, but it is possible to have 2 juries sit in a case and then have somebody get up and leave during a part that's not for that jury. They could do that. I've seen it happen in criminal more, but in civil, the rules of evidence are different. You're going to see things that overlap so much because so many of these causes of action are going to overlap. The things in this civil complaint from Karen Reed are essentially the things she's arguing in her defense on the wrongful death, right? So it is a shift between the 2 of them and a crossover between the 2 of them. So you might not need 2 juries, but that is going to be fought over in the wrongful death case. And I imagine that the O'Keefe family is going to say, you know what we don't want? We don't want all of this in the wrongful death case. because it's going to make everything take a lot longer and be much more complicated. But for judicial economy, you're going to see Karen Reed's team arguing, but this is our defense. This is our entire defense. And because this is our entire defense, we need to have it presented. And so if it's both being presented, shouldn't they just all decide it at once instead of having it happen at 2 trials? Wouldn't it make sense just to do it all with one jury together? And we're going to see those arguments come up. That case is back in court on Friday, so we'll see. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.